Please.
Anand, you can take over.
Yeah. Good afternoon and warm welcome to the speaker, Datuk.Prof. Sundra Rajoo, all the parties to the Contd. In its endeavor to familiarize, popularize, and to promote the AIADR practices, CNIC has been conducting the study series. The positive impact of COVID is a realization of the potential of this platform through which we could connect the erudite speaker and illustrious participants. The response has been tremendous. Seneca was formed in the year 2004 under the aegis of Trust for Alternate Dispute Resolution with a non-profit motive to serve the society at large and to resolve the legal disputes by providing AIADR services. Seneca's Mediation Center was inaugurated in the year 2006. Seneca has its panel of arbitrators, and apart from being an appointing authority in its institutional arbitration, Seneca provides venue for ad hoc arbitration, conciliation, mediation through its state-of-art venues. Today's topic to the study series is how to write an international arbitration award. It is a topic of extreme importance since writing an international award is a challenging one. Writing an arbitral award is different from a written submission or a judgment. All these awards have the formal and substantive requirements. Most of these requirements are mandatory to ensure recognition and enforcement. We have with us today a very eminent, prominent personality, an international arbitrator, Datuk.Prof. Sundra Rajoo, who will be addressing us on this very important subject. Professor Sundra, as he is fondly called, is the founding president of Asian Institute of Alternate Dispute Resolution. He was the director of Asian International Arbitration Center, known as AIAC, during the period 2010 to 2018. Under his dynamic leadership, the institution grew leaps and bounds, both in content and in providing state-of-art facilities. The present state-of-art facilities at AIAC and the position of AIAC in international growth owes it to him. Apart from this, he has held various positions such as President, Asian Institute of Arbitration Group, President of Chartered Institute of Arbitrator, Chairman, Asian Domain Name Dispute Resolution Center, Deputy Chairman, FIA Adjudicator Chamber. His role of honor includes being the founding president of Society of Construction Law Malaysia, Malaysian Society of Adjudicators, and Sports Law Association of Malaysia. Datuk.Professor Sundra has numerous co-created three panel. He has authored, co-authored, and edited several books on arbitration, contract, and construction law. At times, he serves as visiting and adjunct professor at University Technology Malaysia, University Kabansang Malaysia, University Sains Malaysia, and University of Malaya. As a protocol for today's meeting, the speaker would be making his presentation for the first 50 minutes. To avoid any disruption in presentation, the questions will be taken towards the end and can be posted in the chat box or by show of hands. Over to you, Professor.
Thank you, Anand. I am very honored and privileged by this opportunity given by Seneca to present this talk. I chose this topic simply because after COVID-19, we do expect a lot of disputes to come about, and many of you all would be called upon to actually participate in an arbitration, either as counsel, maybe you are one of the parties, or perhaps you are sitting as an arbitrator. And the way I've structured today's talk is basically, when I say how to write an international arbitration award, we have to think about what will be an enforceable international arbitration award and what will be the contents of it. So I will go through stage by stage and try to take you through the process that you start to think about the arbitral award, whichever way you're looking at it. But I'm going to actually talk about it when you are an arbitrator. So the important thing is that an international arbitration will normally be an arbitration where one of the parties is not domestic. I make it very simple. I mean, in the Arbitration Act, it will be described in different ways about places of business and all these things. But we take it as a very simple that one of the parties is not a domestic party; it's an international party. So in this instance, I'm seeking this arbitration in India, that is in New Delhi. So the lex arbitri will be the arbitral law will be actually Indian law, Indian Arbitration and Conciliation Act 1996, and then the party that I'm assuming could be either a Chinese party or could be somebody else. So I'm going to actually start off by what is an arbitration award. You will find that if you go into your act and if you go into books and all these things, you'll find various definitions will be given. But in the act itself, you won't have a definition. So we have to rely on, for example, Black Law Dictionary. So an arbitration award is the decision or determination rendered by arbitrators or commissioners or other private or extrajudicial deciders. What it really means is not something that's decided by the court. It's outside the court. And they will put it in a document. And the award is called, that decision in writing is called an award. So arbitral awards under the New York Convention, which is for international enforcement of arbitral awards, will include not only awards made by arbitrators, because these are persons, or arbitral panels, but also arbitral bodies. That means an institution can make an award. Now, what are the types of awards that are possibly available? The types of awards would include, I think the main types of award that you will come across is final award, interim award, partial award. You may have consent awards or agreed awards, default awards, provisional awards, sometimes institutional awards, and sometimes awards that deal with jurisdiction. It will be called jurisdictional award, and then an award on cost and interest. Now, the most important test of an award is whether it deals with the substantive rights and extinguishes the original cause of action. That means it settles the matter for good. It is not a procedural arrangement. So a procedural order will only deal with going forward in the arbitration itself, but an award itself will deal with the substance of the matter and make a decision on it, and it is determinative of that matter, and it is final and binding on the parties. Now, the next question is, for whom are such awards written? Because we know it has to be a written document, and who do you write the award? In fact, I normally, when I sit down and write the award, I'll be thinking, who shall I write this award for? And particularly if it's a contentious matter, we will deal with that in such a way that I think I think something is happening. I'm not sure what it is. Let me do this. Sorry. When you think of who the award is written for, if you ask different arbitrators, they will say, I'm doing it for different reasons. One, you write it to the parties. The other one, to the parties' councils. You write it for the arbitral institution. Let's say it's an ICC award. There's a particular format the ICC would require you to do. A lot of Indians go to SIAC, Singapore International Arbitration Center. There is a particular way of writing the award. And finally, the award has to be written for the enforcement court. I think that is basically the main people that you write the award for. But many situations, when you write the award, you must actually think, who are you explaining this decision that you are making to. And you are giving the reasons for the conclusions that are reached. And the most important person is sometimes the person who has lost. The party that have lost the arbitration would be very, very interested in knowing why they have lost, and they will look for reasons to challenge it. And that is why you have to be very careful when you write the award. Now, where drafting of the award is concerned, there is no set form, but generally the award, unless there's no specific arrangement that this award must be like this or this, whatever I'm giving you is just a sample. But there are sometimes formal requirements and substantive requirements, but it depends on the arbitral agreement, and it depends on the arbitration legislation, and it depends on the law governing the arbitration. Does it require it to be in a specific form? I give you an example. If you do an arbitration, let's say under certain institutions, they will have a format that you have to follow. So I think you need to understand that. And sometimes the arbitral agreement may say that I want this in this format, and this is the particular way. Now, the formal requirements of the award, there are two parts to it. There is formal or procedural requirements of the award. The other one is the substantive award. I'm going to talk about each of them in detail later. But the formal requirements in the Arbitration Act itself, in most arbitration legislation, requires an award to be in writing. In the old days, you can give an oral award. And if you give an oral award, now it is not binding. And the award itself must be signed. There is a reason why the award must be signed, to show that it is actually delivered by the person who is appointed as the arbitrator, or it's by the arbitral panel. And signature, there is a signature requirement is like, let's say in a panel of three, do all three arbitrators have to sign the award? Not necessarily. In fact, legislation required a majority decision, and as long as the reason why the signature is missing, or the person has not signed the award, let's say a dissenting arbitrator has not signed the award, that reason is put down in the award, that is good enough. Now, the next formal part is that you must identify the parties correctly. Who is the claimant? Who is the respondent? You have to put down the address and explanation of where who they are very, very clearly, because these are all for enforcement reasons. And then the fourth thing will be procedural history. When you do an arbitration, it is a process. From the time you are appointed until you deliver the award, there will be a number of activities going on. Now, when the arbitration commences, they will actually write to you or approach the arbitral and constitute the arbitral tribunal, and you will have to actually show where and how you got appointed, and show the arbitral agreement, because it's either parties have consensually agreed to be you being appointed pursuant to a written agreement, or it is an ad hoc arbitration agreement where they agreed to follow an arbitration and they have decided to appoint you. So that will be the starting point, after which you will normally call a meeting, a preliminary meeting. When you have a preliminary meeting, a case management meeting, you will set out directions. That will be part of the recitals that you will talk about. So you will have the parties, you will talk about how you got appointed, what is the arbitration agreement. After that, you will go on to, let's say, directions that you are given. And then were there any applications, interlocutory applications that you are dealing with? And subsequent to that, when did you hold the hearing, how long the hearing, and how many hearing dates, or was it, and who are the witnesses who came? All that will be part of what is called the recitals or the procedural history. And then the important part is the dating of the award. That is a formal requirement, because that will have some impact on how the award becomes effective. And it also affects enforcement issues, payment of interest, and also limitation. The seat of arbitration is a considerable of importance. Where the arbitration is seated is what the arbitral law that will be applicable, the legislation that will be applicable. So for example, I can be in Malaysia, I'm now in Malaysia, but I can do an arbitration seated in India. That's a difference, because the seat of the arbitration and the place of the arbitration is differentiated from the venue of the arbitration. So let's say arbitrators, many of us, international arbitrators, we are not in the same place. I give you an example. I have an arbitration where one arbitrator, I'm in Malaysia, another arbitrator is in, let's say, in Singapore, another arbitrator is in Africa. And the seat of the arbitration is, let's say, in an African country. That's a real situation. So the seat is an idea that this is the applicable law as far as the arbitral legislation is concerned. We will follow the law of the arbitral legislation of the seat governing this arbitration. Then the other point that comes up is that when you have prepared the arbitration award, you will have to publish it. That means you have to notify the parties, or the arbitral tribunal will notify the parties, ask them to pay up the fees if there's any due, and then that will be called publication. There will be a date, and that date will tie back to the date of the arbitration award. And publication is important to inform the parties so that they can actually collect or receive the award. And that will be the date that of the, it may be different. I know normally sometimes you say I'm publishing the award on this date, and it will be dated this date, but because they didn't pay your fees, you may hold on to the award because you have a lien on it. Now, the contents of the award itself in detail will be, you need to talk about the contract itself. What is the contract that gave rise to this dispute? And the contract could be a standard form contract, it could be a specific contract governing the relationship between the two parties. And then you have to zero in on the arbitration agreement or the arbitration clause. Then you have to show that there was a dispute or difference that came out from the contract. When they perform the contract, during the currency of the contract as it is being performed, there was actually a dispute or difference. Even the contract could be completed. They couldn't agree on the final account, for example. And then when the dispute or difference arises, the arbitration clause will kick in. And when it kicks in, there will be an appointment of the arbitral tribunal. We call it appointment constitution. And then the next part of the award, we should talk about the dispute. What is the dispute between the parties? And the dispute between the parties is normally will be set out in the, let's say we are common law, you will be having pleadings. In some situations, you will have a statement of case, a statement of defense, counterclaim. But basically, it is the pleadings which will be the dispute details, and then what are the reliefs they are asking for, similar to a court, but that will delineate the extent of the dispute and the extent of the facts that you have to cover. Then I've already spoken about the procedural history, which is basically to say about what is the story, the process that actually happened as you were going on to carry out this dispute. Then, as you are going through, you will pick up item by item which issues, and you will provide your reason for why you are going towards a particular decision. Then you will come to the decision, you have to say the decision, and it's a way of saying the decision. I find and hold, or we find and hold, that this is the answer for that particular issue. And then at the end, you will summarize it. So I'm giving you all an overall view of how the award is done. And then that is the formal part of the arbitral award. Then there is what is called substantive requirements. Now, substantive requirements is what is the arbitration award got to do? What must it do? The arbitration award must resolve all the issues that have been referred to the tribunal. That's the difference between the court and arbitration. Let me explain to you all. In the court, you may have 10 issues that you raise in your pleadings. And when the 10 issues come out, the court may say and choose 2 issues and say that these 2 issues is determinative of the dispute between the parties and rule on it. In an arbitration, you can't do that. If they give you 10 issues, you have to decide on each of the 10 issues. So I think that's an important difference between arbitration and litigation, the court judgment. So the arbitral tribunal has no discretion on deciding which issue it doesn't want to solve. Even if it doesn't want to actually make a decision on a particular issue, it has to say that it is not making a decision on that particular issue and give a reason. For example, I have been situations, let's say there are 10 issues. We will say that this one issue, we are not dealing with it because it's covered by this issue. But you have to explain that. But in the courts, they may just say it generally. They said, okay, 2 issues determine this whole thing, this is the answer. But an arbitrator cannot do that. An arbitral tribunal cannot do that. The second point is that the arbitral tribunal must disregard all extraneous issues that are beyond its jurisdiction. It's very important that if somebody asks you to look at this contract, you don't go and look at another contract. You know, somebody says that, I give you an example. I went through this many years ago. This is a story that is quite common here. The arbitrator was told that we want you to just look at this particular dispute, although there's 2 other contracts involved, but we don't want you to look at the other contracts. The arbitrator, what he did was, he looked at this contract. He said, I cannot look at this without looking at these 2. And then he started to make comments on all 3 contracts. And at the end of it, the award was set aside. I think that is a pitfall that you must watch out for. And it is something that we must continuously be very conscious, because the setting aside provisions under most of the legislations, let's say 34 in ancestral model law and all these things, will deal with, are you going beyond your jurisdiction? The next point is that every issue, you must make a decision which must be final, and it must be unconditional. You cannot actually say that it can be in the alternative. You have to make a decision that is actually clear, final, unconditional, and most importantly, it must be certain and capable of performance. That means you ask something to be done. Let's say a payment of money, it must be done, it can be done. But you normally, let's say, very rarely arbitrators order specific performance, very rarely. Only the courts do that. But arbitrators hardly do that. The next one is the award itself, and this is very, very important, that you must always have it in your mind that it must be enforceable by the courts. So at the end of it, enforceability is what converts an award into something that can be collected, for example, into a judgment, and the judgment will give you all the remedies and all the, for example, a writ of seizure. It can give you, a garnishee and all these things. You can use whatever the court's powers there are, but it must be capable of enforcement by the court. The courts will enforce it. And particularly India has become very, very important. It's not contrary to the public policy of India. I think this has become a very big issue in India, particularly. But in some other countries, it's public policy, like in Malaysia, is only limited to fraud and dishonesty. You know, there is some cheating or something like that, which is in the arbitral award itself, or bribery. So that becomes a public policy. So public policy is limited in certain countries, but in India it's a bit wider. So that's fine, you know. But each country chooses how it wants. That's why when you're writing the award, you must always think about where it's going to be enforced. But generally, if you follow all these things, it can be enforced in all over the world. But under the New York Convention, you have about 170 countries who are members of the New York Convention. Your award, an international arbitration award, should be enforceable in any of those countries. So you have to write it, but you must keep a special lookout, particularly if it's going to be enforced. Let's say if it's an Indian party and a Chinese party, so you have to think, or let's say an Indian party and a let's say not Chinese, Singapore party, you have to make sure that it can be enforced in these two jurisdictions where the assets are. So that is the issue of enforcement that you have to look. And I think Mustil and Boyd in the 90s particularly, they basically said that the awards actually must be cogent, it must be complete, it must be certain, it is final and enforceable. It is saying the same things in a different way. So I don't have to repeat that. Now we go to reasons. One of the important modern attitudes towards award writing is that you must provide reasons. You must explain how did you come to that decision. So in doing that, these are the following things that you will have to look at. One is, what is the evidence that is before you? And evidence comes in different ways. One, it may come in terms of oral evidence, somebody giving you or witness in a witness statement saying, I know of these facts. The other person may actually be saying that these are the documents I'm relying on, these are the evidence that we have. And then what will happen is that they will actually look at the evidence and make submissions on it and say this evidence is applicable, this evidence is not applicable. And sometimes there are some facts that are all agreed upon. And when they are agreed upon, it is actually something that there's no dispute about it. And then you have to pick up the issues again, which are in dispute, item by item. And for each of these disputed items, what is the finding of fact that are applicable to this issue? And then what is the holding of opinions on law? What is the applicable law? Because maybe the contract has, let's say the substantive law is Indian law. So that will be the law that will be applicable, which is different from the procedural law of the Arbitration Act. And then finally, you must come to a decision. So you will make a number of decisions when you're writing the award because there are so many issues. Item by item, you have to deal with it. Okay, now I'm going to come into the format itself. Now, as I said, there is no set form of format. I mean, this is something that many people have developed. Some international arbitrators write it differently. You will find, let's say, if you do certain institutional arbitration, they may even have a checklist. I have a checklist later in the slide to show you. But the first format that you will have is you have a cover page. And the cover page will be, for example, it will say, I give you an example, I mean, there are some awards here. It will have a layout. The layout will be in the matter of the Arbitration Act and in the matter of the arbitration, like what I've written here, between the claimant, what's the name of the claimant, and between the respondent. And on the cover page, you actually state the kind of award. As I mentioned earlier, there are final awards, partial awards, consent award, additional award, jurisdictional award. But let's say this is a final award. And then at the bottom of the page, you put the date of the award, and you also put your name, the name of the arbitral tribunal. We assume that in international arbitration, there will be a panel of 3. But in, let's say, in a domestic arbitration, normally there's a panel of 1. But in international arbitrations, I've set and also as a panel of 1. So it depends how the arbitral clause is written, and that is the way it's done. And earlier I've spoken about procedural history. You all remember? I spoke about you have to set down the background and the process of the arbitration as it took place. So the first thing that you do is normally after setting out the parties, you will say something, this is the introduction. Then you say, this is my final award between party A and party B. Party A, the address is this. Party B, this is the address. And then you say they had a contract. What is the nature of the contract? It was, let's say, a sale and purchase agreement, or it's a building contract. And then you have to say what is the date of the contract, who are the parties to this contract, and you give a brief description of what the contract is supposed to cover. And then you zoom in on the arbitration agreement, because that is where you are getting your power from, the arbitration agreement, which is the clause in the contract that is the arbitration agreement. And then you will have to basically set that arbitration agreement. I normally set it out in full. But sometimes people may just say that this is the clause and go on. But normally you find if you're doing institutional arbitration where there is scrutiny, certain institutions will do scrutiny. That means they will check your award before they allow and approve it, before they allow it to be released to the parties, to be published to the parties. And they normally will have a checklist. They will have a particular format. They will have they will go through your reasoning, and they will also check whether it's sufficient. But let's say we are doing an ad hoc arbitration, which is very popular in India, then you will have to do good with it, because you must think of the enforcement. Most important, the enforcement of the arbitration award. So if there is an arbitration clause, then you set out the arbitration clause in full. And if there is no arbitration clause, and the arbitration was decided subsequent to the parties' agreement, then you identify the relevant document. Sometimes, parties will say, there are two types of arbitrations. One is, of course, a submission to arbitration in the agreement itself. Sometimes there will be a subsequent submission. That means after the dispute has arisen, before that, they may have it in the contract itself. They say in the event we have future disputes, this will be the applicable clause. But sometimes they may not have an arbitration clause. They will agree that we should go for arbitration. And if we decide to go for arbitration, then you have to have an ad hoc arbitration agreement. What is the scope of the arbitration that you want to do? Some people do it very simple. Some people may not actually have much details, but I think that's problematic. Normally, other people may write down what is the arbitration clause that they agree to go for arbitration. So the next item, after you have set up your arbitration clause, that's where you get your power from. And then you talk about the dispute or difference. You will have to say that there is actually a dispute or difference that have risen in the performance of the contract, and you explain, set it out very briefly, what is the nature of the dispute. So it could be, let's say, somebody has delivered something and he has not been paid, or the delivery, the item that's been delivered is it's not up to par. It is not per the contract. So I think that could be also an issue. So then you said that that's the dispute and differences. Then you talk about your appointment, the arbitral appointment. How were you approached? Was it a party that asked you to, one of the parties that asked you to actually give a CV, give your terms of appointment, and when it was, and then you were then appointed? Let's say if it's a panel of three, two parties will appoint each of their own arbitrators, and normally the third arbitrator is appointed by the two arbitrators or by an institution, or the two parties will agree on a third arbitrator. If they cannot agree, they may go to an institution. So I think the various ways you're appointed, let's say the panel of three, each of them have to be described how they got appointed. So let's say arbitrator A, he was approached by this party and he was nominated and appointed by this party. It has to be stated and when. Again, and also there must be acceptance of that appointment, some form of acceptance. So appointment by itself has to be accepted. Then only you are actually the arbitrator. So if there are two arbitrators and the third arbitrator is appointed, that has to be explained. So then once you have actually written that, then you say the arbitral tribunal was constituted on this date when they all came together. And there is no more, the appointments were perfected and they were constituted, and then the arbitral tribunal has taken over the proceedings. So then, as I said, you actually record all the interlocutory matters that the parties will talk about. The interlocutory matters, they may include things like time limits. Sometimes, if, let's say, if there are arbitration rules, and if there are arbitration rules, particularly in the clause, appointment of where you have the arbitration clause, you will also say that the provision for arbitration is in accordance due to these particular rules. So you know that is the rules applicable. So sometimes interlocutory matters, they will include things like extending the time for the arbitral tribunal to, or limit the powers of the arbitral tribunal. This could, parties can agree and you can record that. Was there actually a jurisdictional challenge? Did one of the parties say, I do not recognize you are not supposed to hear this thing because you're not properly constituted, so I do a jurisdictional challenge. So that is one example. Then what happens if, let's say, parties do not follow the directions that you have given? You may have given some directions, let's say procedural order number 1, you have said, okay, you must deliver your pleadings on this date, this date, this date, this date. You must have bundles on this date, this date, this date, discovery with that. And then you will have witnesses. And let us say that they did not follow one of the particular things and you had to issue a unless order, what is called a peremptory order. I think you have to record it here. You have to record what actually happened. What did you do? This is to show due process, that you are treating the parties equally and in a manner that is fair. Sometimes arbitrators may actually say that I want to not have so many days of hearing, I want to limit the cross-examination. And that again would be an interlocutory matter because you have to hear the parties, set the direction earlier, how you organize the hearing. So orders for discovery, extensions of time, unless orders are basically things that you may discuss about and you may describe what actually happened. So this will be the real procedural things as you're reaching towards going towards the hearing. Now, if there is a site visit or a site inspection, again, you have to talk about it. In the site inspection, you may talk about what date it was the inspection occurred, who represented the party, what was the area that you covered in it, and remember whether that involved some evidence taking. Normally, an inspection or site visit may not involve the taking of evidence. If you are taking evidence, then you will have to record that there was actually like a hearing being held at the site, at the inspection, where evidence was being recorded and how it was being recorded. So that is quite important when you deal with site visits. In fact, I will normally, when I do a site visit, I will say that parties are free to explain what the site visit is, but need not go and explain the issues. They only show what is there for you to see and highlight to you, these are the things that you need to see. And they can argue the nature and the quality of the evidence and the probative value of the evidence in the submissions or in the hearings itself through the witnesses. So I think that is something. After that, you make a general statement in the award that you say, now I, for example, if it's a sole arbitrator, or we, having accepted the appointment as arbitrator or arbitral tribunal, having taken upon ourselves the burden of this arbitration, this is a formal statement, having heard the parties' claims and defense and viewed and considered carefully all the documents, all the evidence presented, and all the written submissions by them, do hereby make and publish this our final award hereafter. This is when the award starts. Earlier, it's all preliminary recitals. You're telling the story, how you got appointed, what's your jurisdiction and all these things. This statement, you notice that I talk about having heard the parties' claims. That means you have heard all of whatever they have raised before you. You have said you have viewed all the documents. You have looked at all the evidence, and you have looked at all the submissions, including written they made. This statement is actually a very important statement, because let's say the party says that in your award, you have not looked at particular things because you may not think that it is important and therefore not referred to it. This catch-all clause will actually help you, because the court will look at it and say, you have said here, you have looked at everything, and you will only talk about the material things that are relevant to the arbitration award. So this is the way I do it. I do it like this. I even do it in an ICC arbitration. I will have this. Some I've seen they don't do that, but they have some kind of statement that alludes to that they have looked at everything. Now the dispute. When you actually go into the dispute, there are possible sections. I'm just talking about how this recent arbitration award could be. There could be a possible section called the dispute. What is the dispute? The dispute, you see, after this, you will set out the pleadings in full, and then now you will talk about the dispute, because then you'll pick up the issues. And in the dispute, you will talk about what is the background to this dispute. What are the events that led to this dispute? What are the agreed facts they've agreed? And you normally should set it out in a very, very non-judgmental language. Don't use words like unfortunately, predictably, as might be expected, once again, those are things that suggest that you have an emotional approach to your award writing. You should just, you don't write like what I've said, that the turbine was first delivered on 15th of July 2019, which was the wrong time. And even after the complaint of July, August, and September 2019, the delivery was not done until this thing. Unlike the first delivery, the type of turbine, it seems like you're very emotional. You're like taking a side. All you have to say is that on the 15th of July 2019, the delivery was done. The claimant, who is the one who complaining, the claimant says is the wrong type of turbine that was delivered. And thereafter, the turbine was delivered on the 8th, because they have no dispute that it was delivered on the 8th. So I think if you say it in this way, nobody will get offended. It's not to offend somebody or whatever it is, but at least to show that you're actually being very, very level-headed and you're not emotional about it. And issues. One of the things that is the difficult part of writing an award and dissecting an award is always dealing with the issues. And you find that you have to list out the issues. And in certain kinds of arbitration rules, like for example, terms of reference, they will ask you to break down by the request for arbitration and the answer to the arbitration from the pleadings itself to take out and come out with the issues. So you will have to deal with the issues item by item. So for example, you have to list out the issues, and then you have to examine them, and you have to get them reorganized. And wherever you can, you try to get the parties to agree. But it's very difficult to get parties who are in disagreement to agree to anything. You may end up doing your own again. So the issue that may come about is, for example, was this contract made on the 15th of May, or was it made on another date, 30th of May 2018? And what about the letter of 16th of July 2018? So these are some of the issues that you may you put out this heading, and then for under each one, you have to deal with it. Then if the contract was made on 30th of May, was it varied by the letter of 16th July 2018? So if it was varied, in what way? See, you can see there's a logical flow to it. And if the contract was made on 30th May, what are the matters that were agreed in the letter of 16th July 2018? What were the terms of the contract? What are the terms? So I think this is the way that you need to deal with it item by item as you're going on. And it's a tedious process. In fact, I think a lot of us hate writing awards. You know, the people who do arbitrations, when they come to write award writing, it's, all the other things are easy to do. When you sit down and write the award, you'll be struggling. And you say, why didn't I listen to this carefully? And then you start looking at the documents and you will try to recognize. And then finally, the issue may come down to, was there a breach of contract and what date does the interest run? You know, for the damages to be awarded. Now, what would be the appropriate rate of interest? Should the interest be compound or simple? And if compound, what will be the rest? So you have to actually deal with each of those items and come up with a reasoned conclusion on the list of the issues. Now, consideration of each issue, this is normally the way it is done, because both parties will have actually made submissions to you. So first, go back to the pleadings. Go back to the statement of case, statement of defense, counterclaim, reply, and then you look and you make a brief summary for each issue, the contentions they have made in the pleadings. Then you take and put it together, the relevant evidence of the witnesses, because you know we deal in a common law country, and if there is actually oral evidence given, witness statements given, most arbitrations they have a lot of witness statements, you may extract those relevant evidence, and then you will find that parties have made submissions dealing with the contentions and the relevant evidence. So each of it you will have to summarize and you have to set it out item by item so that you can see both sides. Party A says this is what I want in my pleadings. This is the evidence that supports it. And I have this case that helps me. And this is the answer that it should be. Party B does the same in the reverse direction. So at the end of it, sometimes they may agree, sometimes they may not agree. You will have to actually decide. So normally each issue or group of issue, you just give some date, some kind of title. So for example, what is the date of the contract? You may decide that. And what about the letter of the 16th July 2018? And then you may have another title called variation. Another title, perhaps added terms. So you can see that we're going like that. Then when you summarize, we talked about evidence. When you're talking about evidence, it is the wording that you should use is, don't call people liars. I think one of the things that you avoid trying to say, that don't say that this person lied in giving evidence, because I think it's very hurtful, whoever reads it. So you're not hurting people, you just want to set out the facts. And I mean, of course, there's perjury involved and all these things, but it is not necessary for an arbitrator to get into that. So normally you will say, like Mr. Chan related, these are kind of words we use: recall, told me, gave evidence that, testified, corroborated. And then cross-examination, you say Ms. Anushka admitted, considered, accepted, maintained, reported, and you know, replied, responded, explained how. And then when you summarize the submissions, when I talked about, you use words like they agreed, submitted, they considered, they contended, replied, they maintained. And I think these are the kind of words that will be very, very neutral and acceptable to parties. You then come to the word findings. When you deal with findings, you have to actually set out your findings for each of the issue with reasons. So what are the factual evidence that you accept? And the reason for the factual evidence may be because you say the witness, you find him credible or her credible, or the witness has made a contemporary record of what he or she has seen, or the witness is actually the right person to know that this happened. So this is when you say the expert, the factual evidence that you that means you have to comment on what is the credibility of the witness and the probative value of the evidence that's been given. Where expert evidence is concerned, expert evidence is opinion evidence, is handled slightly differently from factual evidence. Now, expert evidence is an opinion that is given. Sometimes there are facts that they rely upon, and from that facts, they actually come out with their view of what the answer should be. Now, you must be very careful that expert evidence is for the arbitral tribunal to decide, in the sense that the expert evidence is given in support of the arbitral tribunal. We always talk about that a lot of parties, they employ experts. When they employ experts, they think it is their expert. But once an expert is employed or is actually accepted to the arbitration, what will happen is that that expert becomes the tribunal's expert. So their duty of the expert is to give evidence to the benefit of the arbitral tribunal. They're not supposed to take sides. Of course, that's not true, isn't it? When somebody employs an expert, they actually think that I employ the expert because it supports my case. So when you're dealing with expert evidence, you must be very, very clear of what is the evidence that you're accepting. Again, like the factual evidence, and it may be because it's consistent, it is supported by quoted authorities. The expert is a real expert. He has practical experience compared to the other expert. And I think it is best to say as little as possible impliedly about rejected expert evidence. You don't have to deal so much with that. And then don't challenge the evidence unless it is untenable, totally untenable. In fact, if you don't accept the expert evidence, you don't have to go to town with it. Because the real evidence that's very important is the factual evidence. That's more important. The expert evidence is just an opinion. You don't have to accept that opinion. If you accept it, you have to give reasons why you accept it. So, because it is not a factual evidence, it's just an explanation. It's a view of how you should form that your own view. Then, if you have accepted specific evidence, and you have to say it, I accept this thing because it's credible. I've rejected this contrary evidence on the other side. And then, if you're actually rejecting some evidence, you have to actually talk about that it was not contemporaneous. The document is actually later, is not related. That's why I said, please avoid calling a witness a liar. Don't do that. And even if you are convinced that he's a liar, you can, the way I normally do it is that I say that the witness had some difficulty of recalling this particular matter, and I didn't find his evidence useful. But I will never say that he's a liar. Oh, I will say, I mean, we are very fond of using these words, very economical with the truth. Like that's just as like saying he's a liar. But I try to avoid all those kind of things because people get hurt, and there's no point in an award. Your job is actually to make a finding, and you have to make it as not as emotional. It should be actually quite calm. It should be actually very, very reasoned, and it is actually a document that someone will accept that this is a fact. So I think you must always give a ruling on the conflicting submissions on legal matters. Example, on the contract that is made, the interpretation of the contract term. So when we come for this discussion, so for example, on each issue, let's say on issue 1, what is the date of the contract? So you will talk about, let's say, the claimant's facts of 22nd May 2018 is a counter offer to the respondent offer of May 15, 2018. Sorry, no, it's not 16, it's 2018. And then the same will be this counter offer, was it accepted by the respondent by this letter of 30th May 2018? And then you say that then the contract was made between the parties on 30th May 2018. This is I think we do this all the time. You will do it in the submission, but when you write an award, you have to do a balance. You say submissions, you do it in one way. That's why I say it's a bit different. When you write an award, you have to take both submissions, look at them, and come to the right answer. There's only one right answer, your answer. And then next one is damages. You will actually make a finding on every issue, on a number of issues, and you will actually have established as far these findings as far as they are in dispute. So you will then look at what are the relevant duties imposed on the parties, the obligations between the claimant and the respondent. Is there been a breach of these obligations, and whether there's been loss suffered by any party. And if there is loss, will damages compensate the loss? And then how do you calculate that loss? And if there are actual figures, you look at the evidence that's presented from you. It can come out from, let's say, there could be a liquidated damages clause. There could be a figure there. It could be receipts that are spent on expenses. So I think that is also quite important that you see these items that are for repairs or for expenses, extra expenses paid to third party, and whether it is actually related to that item. And then you also look, next one is that when you make assessment of those figures, you may even look at percentage loss of use. You may look at enjoyment. You just use the usual rules of damages to calculate. Arbitrators are bound by the law, and they have to do the same thing what a court would do in deciding, because it's a rights-based process. And then you have to decide what date or dates the damages should run from. So a calculation of damages, for example, we say delivery. By clause 12 of the contract, the delivery of turbine was due on 1st February 2018. It was not disputed, sorry, it's 18. It was not disputed that the delivery was made on 8th of October 2018. This constitutes how many days of delay? Then you say, I accept the loss, because you need to somehow establish the loss. It's by liquidated damages. He has given evidence where the item is coming out. You will put it in detail. And he says 5,000 day for each day of delivery delay. There's 5,000 US. And then you calculate 250 days times 5,000 is 1.250 million. So that will be the total damages that you have calculated. The next item you have to deal with in every award, you have to deal with interest. And there are two types of interest you have to deal with. It is pre-award interest. That means it is before you publish the award, because your award will be dated a particular date. Normally it will start from the course of action until the date of the award. That will be called pre-award interest. And then what you will have is called post-award interest. After you have delivered the award, the interest will continue to run until the date of actual realization. And you have to decide whether the interest is going to be simple or compound. And you must look at the legislation. Does the legislation or the contract allow you to do that? At one point in Malaysia, until about, I think, 2017, late 17, until early 2018, the court ruled there was no pre-award interest in Malaysia. So if you had given pre-award interest, that portion of the award would be set aside. Of course, I'm giving you an example, so you have to look where is the arbitration seated, what is the applicable law, and you have to follow that. So you have to look at interest. Interest, you have to look at it definitely, because if there's a sum of money that you're awarding, there is a loss for the use of that money. And the way it's going to be done is either going to be simple interest or it's going to be compound interest. And if you are doing compound interest, you have to explain very, very clearly how you decided to do that, because this is not normal. If you do simple interest, normally there is actually a provision. It is allowed. And then what is the rate of the interest is very, very important. You will look, sometimes it's certain percentage points up from BLR. Sometimes you follow a judgment rate in the court. It depends on the various jurisdictions that you are in, and you have to look at that. And then post-award interest and pre-award interest. The post-award interest will work, it will stop when the payment is made. So they will calculate the interest until the date of the payment, and that interest will be payable. So it is a form making sure that the parties pay up, because they have to incur interest. Because you have ordered a certain amount of money to be paid, and then it will continue. But you have ordered for the loss of that money, use of that money during from the course of action until the date of the award. That's pre-award, and then post-award is after that until it is realized. Now, costs is very important. Arbitration is an expensive affair. International arbitration is even more expensive. It depends what type of arbitration. I don't know about domain name. I think it's quite cheap. Mr. Saravanan will say that it is very, he's not paid well because it's a standard tariff rate, you know. But you will have to deal with things like costs. Because when parties come to an arbitration, they will have to actually incur money. And they will incur two types of money, two types of costs. The first type of cost is cost, of course, we call it cost of the arbitration, the total cost of the arbitration. It will make up of two components, the parties' cost and the arbitral tribunal's cost. The parties' cost will be paying the lawyers, hiring the rooms, paying the experts, bringing the witnesses, all that could be parties' cost. And then the tribunal cost will be the fee that you pay the tribunal. So again, the general rule in most arbitrations is cost follows event. And I think as a lawyer, you would know that cost follows event means loser pays. At what point the loser pays is you will have to actually, as long as he wins a certain amount. But there is also exceptions to the cost follow event rule that was there an offer to settle. It is very popular, you know, like in certain, I don't know whether it's, I've not looked at the Indian legislation, whether there are offers to settle. You can tell me, I have to look at that. But in Malaysia, there is such a provision called offers to settle. That means parties can give a sealed order or a call the bank of order, call the bank offer, and they will say that I offer to settle this arbitration, this is owed to you for this sum of money. But they won't tell the arbitrator, and they would have actually made a private offer or a sealed offer or call the bank offer. And then when the arbitrator is actually going to decide the award, at that point of time, they will tell the arbitrator, please hold back on the cost part. We will let you, we will let you know the offer after you have made your decision. So I think this is to force people not to prolong the arbitration if they have a good offer. Because if the offer that is given is higher than the awarded sum, you get no cost from the date the offer is made. So normally what parties do is that they make that offer very, very early in the arbitration if they are very, very sure that their offer is very reasonable. And if somebody insists that they want to go on with it, then they run the risk of not getting costs if the amount awarded to them is lower than the offer. So then the other thing that will be considered against the general rule was, did the winning party behave so badly? I know I've seen in arbitrations, in particularly domestic arbitrations, where there's so much emotion involved that the party who is actually pursuing the claim wants to make the other party suffer. It could be vice versa, but most probably, let's say the person who's going to win makes all kinds of, just prolongs the matter to such an extent that that it is indefensible. So you're saying, please get on with it. They keep on carrying on, and you may decide not to give the full amount of cost. So you may decide to actually give an amount that is lower than the full amount. Whatever they are asking for, you may actually bring it down, and you will explain why you have brought it down. And then, let's say claims. Sometimes people make very large claims and they get a small amount. They spend so much time proving the claim and they didn't succeed. In actual fact, they lost. So you may not actually give the full cost that they ask for. Like the winning party, did they delay the proceedings also is very important. I have situations where somebody will file the claim and then you will start the arbitration and then they cannot get their witnesses. They keep on postponing. And then at the end of it, the respondent gets so fed up. And then finally, when he finishes, respondent says, look, you cannot give them the full cost because I wanted to finish this early, but they kept on delaying. They didn't bring their witnesses. But how can you actually punish me for that? So I think normally those are the considerations you have to look, but you have to actually hear out both parties. Always remember, you must hear out both parties, that you must give them an opportunity to explain to you and how you should actually decide on cost. And then one thing wonderful about the arbitrator is that you do not need to actually give your award out until you are paid. So I think unlike lawyers, you may give your service and then after that you're not paid. Arbitrators, normally the last bit, we all hang on to our awards and we make sure that we get paid before we actually release the awards. And arbitral institutions also do that. They normally will hold back the award until they can get the full payment for the sum before they release the award. And at times, sometimes one party will pay for the other party and then they will be reimbursed and you will deal with that in the award itself. I will show you all how it's done. And I said, let's say one party doesn't want to collect the award. One party knows that he has lost the arbitration. He knows he's going to lose. For example, respondent. And it doesn't want to pay the fees. It comes under protest. It carries on with the arbitration. After the arbitration is actually completed, when you ask for the fees, the respondent doesn't want to pay. He doesn't want to collect the award. So you have to ask the claimant to pay. And when the claimant pays, there must be some statement in your award to deal with that. And I show you that you must deal with the situation to ensure that the party who has made that payment is reimbursed for making that payment. So let me go on to the award itself. The award itself, it is actually the last bit of the arbitration award. And this where you actually tell what each party is supposed to do. And this part is called the award. We will call it the award. And it must state what is the total sum payable to the respondent or the claimant or to pay to the each party. Somebody has to pay somebody. Normally it's the money. Then what is the interest ordered on late payments on the damages sum, pre-award and post-award interest. And then who is going to pay the costs? And the overpayment by one party in paying, let's say, for room bookings or let's say arbitral fees, how is it going to be reimbursed? And then you must make a last statement. This is a very important statement. All requests and claims by the parties are rejected. That means you have dealt with everything. Sometimes you are writing the award, you may pick up many issues, and then sometimes you may have not dealt with a particular item, but this item will cover it. That if you have not dealt with it, it is actually rejected. So we normally put it, and I'll show you all how it's written. So that award will say something like this. They will say, for the reasons given, we hereby find, determine, declare, and award as follows. Okay. The respondent will pay the claimant a sum of US dollars 1,250,000. Full stop. It's very clear, isn't it? Who is supposed to pay whom? How much? That is very clear. Then you say respondent will pay interest on the United States US dollars 1,250,000 at the rate of 5% from the date of the breach, or the date where the action actually started, 9th of October, whichever you think is the date, and then to the date of actual payment. So it covers both pre-award and post-award interest. And then what is the cost that you have to pay? So the respondent will pay the claimant, because let's say respondent has lost, the respondent will pay the claimant a sum of, let's say 50,000 towards arbitral tribunal's fees. And if the claimant has already paid the whole or part of such cost, the respondent will reimburse the claimant accordingly. So I think that is covering that part. And then the respondent will pay. This is actually for the parties' cost. The parties' cost pay US 100,000 towards the cost incurred by the claimant for bringing this arbitration to collect this money. And then the last bit, which I've said, all requests, all other requests and claims by the claimant or the respondent are rejected. And then let's put this as New Delhi. This final award is made and published by the Arbitral Tribunal on 15th May today at the seat in New Delhi. All the arbitrators must sign it. Now, signing is very interesting. You are sitting in 3 different places. You are sitting in 3 different places. Let's say somebody is in India, somebody is in Singapore, and somebody is in Africa. And the seat is Indian. Normally, the signing page, the chairman will actually write out the award, he will print out the award, and he will ask the co-arbitrators to sign the signing page. Let's say in ICC arbitrations, we need 6 copies. So we will sign the signing page of the 6 copies. We will send from one person. The first person will sign. It will then send to the second person, although we will do by email scanning and all these things, but finally we have to get the actual copy to them. So first person will sign it. It will go to the second person who signs the 6 copies. And then finally it will come to the chairman, who will then date the award. You will find, I will show you all, this, for example, the ICC award. You will find something like this. 3 people sign, but in actual fact, the 3 people have not put the date. I'm the last person to sign. You can see that. I'm just giving you an example of how it's done. So once that is done, you either deliver it to the institution, or you tell them to come and collect it. Now I normally have a checklist. You look at the award. When you have written the award, you just check the following things. Is there a heading, arbitration legislation, rules, definition, designation of parties? Is it all right? Recital, is it correct? Procedural history. Is there a clause covering the hearing of the parties? Did you speak about that? When the hearings were held? Then what were the agreed facts? Was it an issue there? Then you look at what are the issues in contention. Then what is the findings of fact, holding of law, reasons for each issue you decided. And then is there a decision on each issue? Make sure there is a decision on each issue. And is there a decision on interest? Then you look at the summary, then you summarize. We will bring to collection as the summary of all the decisions and the award. And then you check whether your calculations are correct for the damages. And then you look at the award, who is going to pay whom and within what time. Is it correct or not? You just check that. And then have you made a decision on cost? Is the names put in, signature, and is it been dated? That's it. In the old days, we used to have a witness signature. Now we don't seem to have it. When I first started in practice, I used to have my secretary actually witnessing my signature, just in case I died somewhere, or people challenge the signature. This is not the arbitrator's signature. Then there's a witness that can come and say this is the arbitrator's signature. So I think nowadays we don't bother because it's quite contemporaneous. It is done. But let's say if you are in a situation where you are not sure, then you can have a witness attesting your signature. Then you check the recitals. You check the recitals. Is the contract is identified properly? is the date there, parties, look at the, again, the arbitration clause agreement, show how the dispute arose, was it referred to arbitration, how did the appointment come about, how did you accept it, state that you have jurisdiction or not, and then state matters that you have decided are arbitrable. Arbitrable. Sometimes, some things are not arbitrable. They may ask you. Let's say if it's a criminal matter, it is not. You cannot arbitrate on a criminal matter. So you may say that you have no jurisdiction to decide, even if they say they want you to decide on the criminal matter, because it's only a state can do that. That is not arbitrable. Then you detail the proceedings. Then you do a final checklist. This is very important. We always get confused here. Have you used the correct names and references to the party? Sometimes we mix the claimant with the respondent with the claimant. You will find, that's where we always, because you get so involved in the writing of it, that you may not realize that you actually mixed it up because you're looking at it. What I normally do is that after I've written the award, I normally will put it aside and then come back after a day or two and then read it again, just to do this checking. And then you have to check whether you have considered all the evidence, because if you are, let's say you're doing an ICC arbitration, they will ask you, why you didn't put this in, why you didn't put that in. Can you actually explain why this item, can you expand on this item when they do the scrutiny? If you have excluded any evidence, that is, have you excluded evidence that is not presented to you? Sometimes because you are very clever, you are full of information, and you are very knowledgeable, you may tend to take secret evidence. You will use your own evidence, your own knowledge, without giving the parties a chance to actually make submissions on it. So that will be actually something that is wrong. So you have to make sure that you exclude such kind of evidence. It is different, that means you have actually a special knowledge of the subject matter, and that you didn't put it to the parties to actually give comments on it. So you make sure that you have not used your own evidence. Some of these calculations that you have done cannot be explained. You must make sure that you can explain. In fact, I've always this problem. I'm very careful with calculations. I tend to make mistakes. And sometimes it's the simplest mistake. You are using, nowadays we don't use our brains anymore. We don't do mental calculations. I don't know. I don't. I actually use a calculator, and sometimes you can get different results at the same thing you're pinning in, and then you wonder what's happening. Then you do a mental calculation, and you say, oh, okay, then this is the correct one. So I think you have to check that and see the rates that you have used are correct, and then you have to look at have you decided all the matters that have been put to you? That again, go back and ask yourself that all these items. You can reject some of the items. You say that this item, I've considered it, but this is not relevant. That's fine. But you must deal with the item. Then you must actually then decide, have you decided on something that was not put to you? That means you went out of your terms of reference. And then does your interest award run from the date of inception to the date of the payment? So you have to check that. One of the requirements nowadays in most institutions is that you need to actually paragraph number the paragraphs. You can see, so you will number all the paragraphs, and then you have to actually decide whether you have decided on the cost and of the award and also of the parties. And then you ask yourself, after you have finished all these things, when somebody reads your award, can they understand what you have written or not? They must understand what you have written, because that is the most important thing, because if you are writing a story book, this is not fiction. This is actually about facts. Does the story make sense? Is it complete? So I think then we'll go to some decision making. It is actually, first thing is that to write a coherent award, it is a practical application of skills that you have learned, how you organize your material and how you analyze things. And just focus on the issues that are raised in the arbitration. Don't go out of it. just raise, I keep on stressing that, because a lot of us will tend to, because we tend to go outside and we may even do our own, be very careful about doing your own research, If you don't understand something, you can try to understand it, but don't bring in a case that is not being quoted to you. If you want to bring a case that is not quoted to you, it must be tried. Everybody knows about that case. In fact, I will always say the case was not quoted to me, but in a well-known case. I don't even state what case it is, or it is tried law. So I think one of the things that you must understand, you may be a very, very clever person, full of knowledge, understanding that area of the law very well. It doesn't mean that you have to write down everything that you know. It is only what is applicable. In fact, you should only use what the parties are giving you, and then you will use it in such a way that you can tell the story by putting in the principles that expound it, trying to accentuate the parties' explanations. And then that's why I said, you're knowing all the legal principles doesn't mean that you have to put it into the award. Then identify whatever the factual issues are, what is in dispute, what is agreed, and then which paragraph of the submissions, the party submissions you have admitted, and which one you have denied, and which has been denied, and what is the defense, and what is the defense that's likely to be made. Then analyze. You can do research. A lot of us, sometimes we don't understand the subject area. Sometimes the parties don't explain it. Sometimes you get one good party counsel on one side, one bad counsel on the other side, and let's say the submissions are not balanced. Of course, it's not the arbitrator's duty to actually improve the quality of the submissions, but or improve the quality of the counsels. But there must be at least some kind of balance that you need to bring into. Say, although this is not raised, you may actually try to check. And sometimes do go back and check the counter. When somebody submits you a case, they will highlight to you, this is what they are relying it. And I advise you, read the whole case. Read the other paragraph, because you may find the other paragraph is actually contradicting. So you must be very, very clear on the cases. That is why whenever I ask for submissions to come in, I ask, they can actually state whatever cases they are relying upon and which paragraph they're taking, but I require the full case to be actually attached in the documentation, in the bundle of authorities. So I think this is and then let's say there are customs and trade practices. So you need to find out how they actually come up with these trade practices and all these things. It must be actually tendered in evidence. You must make sure it just doesn't come out just like that. Somebody must come in and explain, or it is actually accepted and is put, this is the trade practice. For example, if you're doing palm oil arbitrations, there's let's say the contract itself has certain particular requirements on what the technical issues are, and there will be a table there, and that is the trade issue that they basically trade and custom practices they use. So then you look at the legal basis of each claim. Who has the burden of proof, and has the burden of proof succeeded? Has it been satisfied? So the person who asserts must asserts must prove, And then what is the standard of proof in a civil matter is on the balance of probabilities. So just remember that. So when you are actually analyzing evidence, think about that, and then see what are the defenses that have been raised. What is the factual detail that are needed to be established. And then one of the things, the secret you must do is you must start writing the award while the matter is going on. Don't wait until everything is finished, then you start to write the award. If you do that, then you find that you will be delayed. So many of us will actually start writing the award, particularly when we know the matter is going on. The recitals in which are non-contentious. as I told you, who are the parties, the cover page, what is the contract, what is the clause, all these things, setting out all the claims and counterclaims, defenses, counterclaims, replies, and all these things, until you come to that general statement. And then some of us may even start to set out the issues. So and then you keep on looking how you want to structure the award. Whether you want to do it based on the grounds that the parties have talked about, or you want to look at different ways of writing it. What I've given you is just my style of doing it. Other people may have different styles of doing it. I've seen awards are written different ways. Some people have written, but let's say if you go to an institution, they will require you to write in a particular way. So you look at how it's structured, and then you look at whether you are giving options, especially on the cost of the award and also on the reference. And then next one is sometimes when you analyze the evidence, some people will use a Scotch schedule, a Redfern schedule. They may sometimes draw a line in the middle and then put the points for each side. It depends how you want to make what you're comfortable with. You start going through the documents and notes of evidence. Now it's actually very, very common. You get transcripts. In the old days, the arbitrator will sit down with a notebook. All three arbitrators will sit down with a notebook and start writing the notes. It doesn't happen anymore. I don't know whether it happens in India, but in Malaysia, we normally will have somebody doing a transcript. We even get the parties, each parties will do a transcript which is projected onto a screen. And then everybody can see what the witness is saying, and the witness can also see. And that is normally faster. And then at the end of the day, that becomes the transcript. That becomes the note or the notes of evidence. So once it's you have completed that, then you take an overview, see whether the story it reads like a good reporter, and then and you actually should have a view of which direction you're going. Let me explain to you all. Sometimes when I write an award, I don't know who has won and who has lost until I start analyzing, sitting around writing section by section, and sometimes it keeps on changing. It keeps on changing because the figures keep on changing. Some items you're not very clear. So you may end up writing bits and pieces in different parts. Sometimes you don't write in a uniform way. You all understand what I'm talking about. You will write, you have the structure, you will start to write the issues that are easiest for you. And then you write the more complicated issues, and then you put it together, and finally you will get something that, and then you may go back and you change your mind because you find that you understand this issue better now. And then you will change your mind, rewrite those parts. So I think it's just an iterative process, continually going over and over again. Normally, it's not a straight line. I very rarely seen an award written in a straight line. I mean, you start from recital until the end, you get an answer straight away. It will be choppy. We keep on going back and coming back, but the structure must be there. So I think that is basically the skills that you need. Again, we go back to the basics again. An international arbitration award must meet the substantive part and the formal parts. So once that is done, you make sure that you look at the grounds on what it will be set aside for, and you don't fall foul of that. And once you have done that, I think you're home free. Normally, after you have written the award, forget about it. Don't even think about it anymore. Keep it nicely there. I have all my awards here, 100 over awards. I just look at it every day. And I said, okay, I've spent maybe about I think half my life there writing these awards, and just forget about it. Just continue. Of course, because it's confidential, it's private. You can't talk about it. You can't tell stories about it unless it's reported. And only the court cases you can talk about it. In arbitral awards, you can't actually discuss. And in fact, what I've showed you all, in fact, I'm not supposed to show you. I just wanted to quickly show you how it looks like. So I think that's it. I finished my talk. I know I've taken a bit longer than required. So is there anything you want to ask me?
Yes. Sir, before going to the questions that some of our participants have asked, they've also requested you to share the PPT. If it is okay with you, we can.
No problem, no problem.
I will share it with them and the.
I've also written a paper, then maybe needing some editing, but it can be shared. Like it can be
Now
shared.
I will share the thing as it is. Now we have few questions. Can I go one by one, sir?
Yes, please.
Some difficulty in pronouncing this name. Adi Imi has asked one question. How do you think the choice of law or ruling on jurisdiction, etc., should be treated as interlocutory matter in that section of award, or as an issue for determination, especially where decision is reserved for the award? I think basically they want to the participant wants to ask, when there's a question of jurisdiction and it has been reserved to be determined in the award itself, how do you write it in the award?
Actually, you will have a section on that. You will see that, let's say there is a jurisdictional issue, or sometimes you may need, let's say sometimes they may have substantive, let's say applicable law is this, then they will talk about procedural law is this. So you have to be very clear and you have to set it out in a particular section and what you are using. So I think that's, and then whether if there's a jurisdictional challenge, sometimes arbitrators, what they do is that they will say, I don't want to block this, because the jurisdictional challenge, you can actually go to the court. They will say, okay, I will decide the entire matter and I will also decide the jurisdiction on the first part. And then you can then decide to go to court after that, to check whether my jurisdiction is there. But that is normally you will rule that you have jurisdiction. If you know that you have no jurisdiction, you may want to publish that award. You may want to publish that award to say that you have no jurisdiction, because then so that you do not continue and waste everybody's time. But normally when somebody says that I will actually reserve my jurisdiction decision for the final until I've heard the whole thing, normally that means he has jurisdiction or he or she has jurisdiction, and will explain that before going into the merits of the award itself.
To all the participants, the PPT has been shared in your chat box. You can download it from there. Mr. Stefano Cardinal has got a question, sir. He says, I would like to know from the speaker if he has experience in AIADR and how an award being drafted from a mediation agreement is different from a normal arbitration award.
I think you must go back to the New York Convention. The New York Convention seemed to suggest that there must be a dispute. There was always this problem with the New York Convention. I can't remember the article. So a mediation, in the old days, we used to say that, let's say if you have a mediation and there is actually an award, then after that you appoint the arbitrator, or in an arbitration, they actually have a settlement. And then they have agreed and they ask let's say the mediation is successful. They ask the mediator to become an arbitrator and do an arbitration award. For international award, there may be some problems because of the New York Convention definition on dispute. There is a requirement for a dispute. And if you are actually appointing a mediator into an arbitrator, there's no more dispute because the settlement is already agreed. He's just recording that into an agreed award. So what normally will happen is that you appoint the mediator as an arbitrator, and then let them mediate, and then after that continue arbitrating. You to overcome that. That's why they call it up-met up. And I suppose, unless they have a specific provision, they will respect the thing. Met up is normally a problem for international enforcement.
Yes. Sir, Mr. Surendra has another question. What is the difference in format for domestic and international award?
Actually, in many jurisdictions, is actually becoming the same. Domestic awards are focused on making sure that it is enforced locally in the local courts. And I think most of us will spend a lot of our time doing domestic awards. So you know what is the applicable law. It will be normally very, but you know, in arbitration you can have domestic arbitration with the law. The substantive law could be English, could be Singapore, could be anywhere else. You know, that's the beauty about arbitration, is it? In fact, the law can change either way. But what is the difference? In actual fact, there is no difference. If I really become, most jurisdictions are moving towards that there is no difference between international arbitration and domestic arbitration. They expect the same standard.
Okay. Mr. Ganesh,
but we tend to,
sorry.
No, you know, in some jurisdiction, for domestic awards, there's greater supervision by the courts. You know? They may even refer, let's say, points of law after the award is written. That we used to have that in Malaysia called Section 42 for the court to supervise the award, to decide whether you have got the point of law right, is it? But I think that is slowly going away, and in fact, I would like to say that there should not be a difference between an international award and a domestic award. But generally, I think there is this strong feeling, because given the international enforcement requirements, it will be different. So because you will actually have, I keep on telling you all, think where it is going to be enforced. And once you know where it's going to be enforced, or likely places is going to be enforced, you will be thinking of those places, how you will deal with it. And then you will look at your arbitral lex arbitri to make sure, because the first challenge of the award will be in the lex arbitri itself, where the award is, the arbitration is seated. Of course, you know, we have the Lipo case, Astro case, which suggests that during enforcement, you can also challenge the award, which is again very rare.
In continuation to that, almost, Mr. Ganeshappa has asked, what are the things that we have to see in an award while enforcing it so that it becomes very easy to enforce?
Sorry again, I'm trying to understand. What
are the difficulties that one comes across while enforcing international arbitration awards, and can it be made easier while writing the award?
Actually, you should go and look at the cases where awards are set aside. Just go and pick up any case where the award is set aside, and then you will know why it is set aside. And that is the thing that you must avoid. You know, so for example, if you got the names wrong, you got the facts wrong, or you have, breached natural justice, you didn't give them a chance to hear, you have taken secret evidence. Those are the things that, it is a clash against the public policy requirements. So you will see, when the best way to learn how to avoid awards being set as your award from being set aside, look at the examples of where awards are set aside, and take the reason why they are set aside, and then try to avoid that in writing the award.
Fine. Sir, Mr. Saranan has got a clarification. The question goes like this: an award has been passed, an international award has been passed. It has been challenged, and the challenge was again further appealed, and ultimately the award was held award was upheld. And at the time of enforcement, it has come to the knowledge of the parties that the award has been obtained by some extraneous consideration. Now, what is the recourse?
The award has been upheld.
Yes.
But I suppose they can try to challenge it again, saying that the new facts have come out, that this award should actually be set aside, or enforcement should be refused. I think at the point of enforcement, refusing it, there are other reasons, but it depends. If we say New York Convention, there is also particular requirements that have to be met. And if new things come out, you can still raise it. But you see, the problem is about something about New York Convention. What is set aside in some place can continue to be enforced in another place, by the way. We have seen many of that. What is set aside in India could be enforced, let's say, in Thailand, as long as the assets are there. So we have seen, I've seen, my own situation where something was actually not allowed in a particular place, was allowed in another place. So I think that is the beauty about arbitration. You see, the world is the thing, but there are certain standards you must follow. The rules are quite clear. New York Convention is quite clear. The local legislation is quite clear. Is whether you are following model law or you're not following model law. Of course, we have many countries are model law, but many countries also have their own acts. So yes, you have to look at particular kinds of things. But I think the world is now dividing now into three types of acts. One is actually model law. Everybody says, I want to be model law. Then the second group follow the English Arbitration Act. And the third group, they will do a mix or their own. Or they will have a very old Arbitration Act that is archaic. Maybe let's say the 1940 or the 1930 something English Act, which is not used anywhere in England or anywhere else except in that country. So you have to just check the law as it is there. So that's where the international arbitration is a problem.
Okay. Unlike in domestic arbitration awards, when we find some arithmetical error and all these things, we go to the tribunal and we ask for the correction of it. What happens in case of an ad hoc international arbitration? In case of an institution, the institution rules have it. In case of an ad hoc arbitration, what happens?
Now, in an ad hoc arbitration, you must see where the seat is and look at the legislation in the seat. And normally all arbitration, even very, very ancient texts, seem to have the slip rule. That means you are allowed to correct clerical typos, grammars, if you have made mistakes that are actually not affecting the substance and it's a genuine slip mistake that you have made. If you are going to affect the substance, then it's a different thing. And you will find that in many modern legislation, they even have what is called additional award. They have interpretation of the award. Interpretation, I didn't talk about additional award. I didn't talk about interpretation award. Those are types of award. Additional award, when you have not actually, not dealt with all the issues, the parties will be entitled to ask you to answer those issues that you have not dealt with in an additional award. And interpretation, let's say, and this is a trick that a lot of people use, if you have not written it clearly and they don't understand what you are trying to say, they will ask you to interpret the provision for you, for them. And they will ask you to produce an award. You see, in my lifetime, I've not faced with that so far. Because I have this checklist and I follow all these things, so I've not been faced. But I know people who have been, my colleagues who have are faced with this, and it is a problem, because when somebody asks you for an additional award, they say, how are we going to? I think somebody said it's Section 31 of the Arbitration Act. This must be the Arbitration Act and Arbitration and Conciliation Act is Section 31. I thought that's a form of award, isn't it? Form of award.
Yes, that's form of award.
Most arbitral legislation all around the world will have a provision for slip rules. They make clerical, you correct mistakes that are clerical in nature, that are typo in nature, or they will also have a provision to deal with things that you have missed out as an additional award, or things that are not clear, you may have to provide an interpretation. But normally interpretation is quite a dangerous thing, because if you say, I meant to say this, but I'm actually saying this. So I think that becomes a problem.
The interest, with respect to the interest, there's a small clarification required. What will be the rate of interest? Will it be the rate as found in the contract, or how does it go in international arbitration?
International arbitration, there could be one provision in the contract itself, what would be the rate of interest. sometimes they will say, I did one Hong Kong arbitration. They say it will be the best lending rate of, let's say, HSBC Hong Kong, and 2 percentage points above that. So that will be the interest rate. So you have to calculate the interest rate and award it in that way. But if there is no interest rate stated, then go back to the legislation where the thing is and look at the practice of what is done in arbitration there. You see, like practice in Malaysia, I can give you, we will follow the judgment debt, the judgment rate, Let's say the court gives you 5%. If they give a judgment and there's an amount payable, the interest rate that will be applicable, we can use that interest rate and normally you will explain, I got power to give this thing under this section, and I'm now using the interest rate that normally a judgment will give, and this is the reason, and this is the section of the thing, which is in my discretion. Normally, if you run out, that could be a reason to set aside the award, because if, let's say, you cannot justify, you cannot give an interest rate. Let's say the court is giving 5% and you give 30%. Because there's no, how are you going to justify you must be able to actually explain where did you get this figure from. And your discretion must be exercised even in interest. Most discretion in arbitration, in fact, just like legal discretion, must be exercised judicially. That means there must be some basis and you must explain with reasons, and it must be actually a legal explanation. Now, let me explain one more thing. Never forget that an award is a legal document. A lot of technical people confuse. They say an award is not a legal document. They think it is actually a technical document because I'm doing calculations and all these things. It is not that. It is actually a legal document. The person who will be looking at it will be the court. It will be the parties. They will use legal arguments under the enforcement provisions or under the setting aside provisions to actually bring the result that they want. So think of it as a legal document. I know engineers, I'm an architect, originally. So when I first started, for me, it was a technical document. So I was more interested in the calculations and all these things and getting the figure, and which is fine. But that is part of it. But when you finish off the whole document, it is actually a legal document.
Perfect. That's an excellent answer. So with respect to the principle of functus officio, how does it work in international arbitration?
Functus officio is when you have actually done the final award, you have signed it. I mean, in international arbitration, just like domestic arbitration.
Just like domestic.
You see, functus officio, what does it mean? You have completed your duties and you have no more power. It is a Latin term. Right? It's a Latin term. So when does that occur? In international arbitration, just like domestic arbitration, is when you sign the document and you have issued the document, published it. You cannot recall the document and say, I want to change some parts of it. That means I want to change my decision. That is the real meaning of functus officio. And once you actually become functus officio, the claim is extinguished already. The decision you have made, the claim is extinguished. You have dealt with all the issues. That's it already. So there's nothing left for you to do. In fact, they cannot come and ask you, can you now give me a procedural order or something, because you have no more power.
One Mr. Rimander has got clarification. He says, should all the pages be signed in an award, or how does it work? And can it be digitally signed?
Okay, this is a very...
In fact, you had shown the award where you had also mentioned that only the last page, the signing page would be the last page.
No. It depends where you are, Okay. If you are in the UAE, it requires you to sign every page. So look at the law. Where is the seat of the arbitration and what is the requirement of signature? Normally, we procedural orders we have actually done by the chairman signing, or we will use scan signatures and all these things. But the final award, which is the final copy, is normally signed on the last page. But there are certain countries, certain jurisdictions that require every page to be signed. And I know for one is that UAE, if I'm not mistaken, requires that. In fact, I think the guy was one of my colleagues. He was complaining, international colleague. He was complaining that it took him one whole day to sign the awards. You know, because he had to sign every page, and then there was quite a thick award, and he was actually, and after a point, his signature was going this way. So, that's why I say, just look at the law. Is there a requirement? But in normal places, there is normally just a requirement of signing the last page. And if you make corrections, okay, if you make corrections, and the corrections are made in, let's say, in ink, rather than the type thing, then normally you have to sign. And if there are 3 arbitrators, all 3 arbitrators must sign to show that the correction, that's a proper way. I normally, when I make a correction, sometimes, you know, after you have printed out the award and you have done 5, let's say 6 copies, and then it is institutional, they won't allow you, they'll ask you to reprint, you know. But let's say if you're doing a ad hoc one, and then you feel that you don't want to do that, and it's obvious, let's say you missed out an A, instead of A, you just, so you put in the A and then you sign at the side there. So I do that, but it's rare. That's why I say you have to check it. Sometimes I wish I had a proofreader, you know. You know, that's where, because you get so involved with it. When you're writing it, you get very involved. When you're typing it, and then you're looking at it, and after a while, you can't see it. You only see what you want to see.
Yeah. Me E. Young has got a question. I'll read it out. Hi, can you give an illustration on offer to settle? For example, if the offer is 500,000 US dollars and the cost you intended to award is 300,000 US dollars, does that mean that the tribunal should not award for the cost?
Okay, award to settle works like this. It can be done at any time in the arbitration, once the arbitration starts. Let's start off. It can be from the commencement of the arbitration, since after the arbitral tribunal has been appointed, until the award is done. It can be so what is an award to settle? Somebody tells the one party tells the other party, I will actually pay you so much if you stop this. If you accept it, this matter will stop, in actual fact. But what happens is that if the party continues, doesn't accept the offer, and if it is when it comes towards the end, they will, because they don't have to pay. It's just like making an offer, payment into court for offer. In arbitration, you don't have to pay the amount. You just make an offer to settle. What you do is that when the arbitrator makes a decision, you ask him to reserve the cause, or her to reserve the cause, and then when the decision is, he has made the sum, what is the amount payable, if that sum is lower than the amount that was offered, the cost at that point onwards is borne by, even if the person has won, by the person who didn't accept the offer. So the winning party, let's say, won the thing, and he's supposed to have accepted the offer, but he got a smaller amount than what was offered, so he will be punished by cost. So the cost, it is to be calculated. That's why you see sometimes when they will ask you to reserve the decision on cost, they won't tell the arbitrator until the end. They ask you to reserve the cost, and then after that they will tell you once the decision to make an award on cost. And I'll make a separate award on cost. People should use that more often, because normally it forces people to settle, people to think, look, you know, I may get a better deal now. I shouldn't go through this entire arbitration, and then finally maybe get a figure. It also sometimes it's like gamble. Sometimes people force people to be very careful to not prolong the arbitration unnecessarily.
I think we are coming to the final stages. Mr. Samuel Shaker, he's got a question. He says, if a part of an award, a speaking part of an award has been omitted to be mentioned, can this be stated in an corrigendum?
In a separate document.
Yes.
That's what you mean, in a separate document.
Yes.
It's a, you know, I mean, you know, the old days, people used to give awards and they will say the reasons are not part of the award. I think when I first started arbitration in 1990s, the technical people were very, very afraid to give reasons, you know, because if they give reasons, then they find the reasons will be actually used to set aside the award. So what they will do is that they will write the award out. They say, this is my award with the recitals and all these things. Then they will have another document they call reasons, and they will say the reasons are not part of the award. And they will say that for them, but that is no more allowed, because now under most of the Arbitration Act, Uncitrul Model Law, English and all these things, the award must have reasons. And if you miss out on the reasons, there are two things that can happen. One is that, of course, if it's insufficient reasons altogether, then the award can be set aside because there's no explanation how you came to the thing. The other one is the courts can actually ask you to provide more reasons. Send it back to you. Please give me more reasons. And if they are not happy with it, they may set it aside because you are obliged to give reasons. And what is the debate has always been, what is the extent of the reasons you give? What is sufficient reasons? And what is the difference between reasoning and reasons? So all these things are all being discussed. But at the end of it, I suggest set out the parties' contentions. Issue, you say parties, this is issue. Then you say this is the main points that they are making. Their submissions are this guy's submission is this. And then you say my finding and my reasons are this. The way you will write it out and you look at each and then you come to something and then you come to a decision. So that will be sufficient.
I think pretty much we have come to the end of the questions. Thank you so much, sir. I don't think so we could have got anything better than this. The knowledge that you put on us is tremendous. In the given time of around about 2 hours, the amount that we have learned is huge. Humongous.
No. Sorry, I didn't realize we were talking for 2 hours. I was when we first started. We had 40 slides today. I got nervous.
In fact, we also did not realize. Only when I wanted to complete it, I wanted to see the timing. I realized it was 2 hours. And we also thank all the participants and the participants who had posted all their questions. Very interesting questions they had posted. Thanks for your active participation. Thank you so much, sir.
Thank you so much. And all keep safe. You know, and we will meet. We will meet. You know, we will meet.
Yes.
All the best to everyone. If you are in places you're supposed to sleep, good night. If you're places you're supposed to work, good morning. Okay. And everybody have a good day. Okay. Yes. Bye bye.
And I would like to announce that on 22nd May 2020 at 6 p.m. Indian Standard Time. We'll be having the topic on prominent cases of India related international arbitration by Mr. Saurabh Jaiwala, a very prominent international arbitration counsel. He'll be addressing us on that day. Please do register and be present. Thank you.
Thank you. Thank you. Bye-bye. Okay.
Thank you.
Keep safe. Okay, bye-bye.
Bye.
Bye. Bye.